I was asked to speak about recent case law on inheritance and gift tax. And for me, the question arose, what is recent? Because at my age, actually, everything seems recent, you know? And there have been 20 years now of inheritance and gift taxes. So actually, for me, that's all recent. And I have this ambitious plan to deal with all the cases, or practically all the cases. And it makes sense to me because I will demonstrate that what happened over the past 20 years is quite logical, quite consistent, and you can see the picture, the entire picture. Finally, I will focus on the last two cases. They deal with German law, and then everything will be clear, I hope. And things are much easier than yesterday. At least I'm going to present it as easy. But first of all, before we dive into the subject, it's very important that you understand what this is all about, and that we're dealing with double taxation in some cases, not always, by the way. We're dealing with cross-border situations. We should distinguish between unlimited tax liability and limited tax liability. That is very important. So unlimited tax liability is worldwide taxation on the basis of a connecting factor. And the connecting factor can be residence, nationality, domicile. And the question is the residence, the nationality of whom? It can be either the residence, nationality of the deceased, or some countries, they have worldwide taxation on the basis of a connecting factor with the heir. So that's important to note. And then, and that is often the case in these cases by the CJ, there can be limited taxation. And limited taxation is always on the basis of situs. So we have two things, unlimited taxation and limited taxation. And that situs property may be defined in a very narrow way, like in Belgium, like in Luxembourg, it may only apply to real estate, or it may be broadly defined, like in France, Spain, in my view, also in Germany, but it's somewhere in the middle. So it's important that you have that in mind when we start dealing with these cases. And what I intend to do, I want to talk about Article 63 of the Treaty on the Functioning of the European Union, which deals with the prohibition on the restriction on the free movement of capital. There are also other freedoms at stake in these cases, like the freedom of establishment. But most cases deal with this freedom on the movement of capital, freedom of the movement of capital. And when I go through these cases, there are actually three issues I'm going to discuss. First of all, deductibility of liabilities. And we will see, I will deal with 4 cases which deal with this issue, deductibility of liabilities. And these cases are always dealing with limited tax liability. So it's about situs property. The next issue I'm going to discuss, and maybe it's also interesting to note that with regard to the first issue, deductibility of liabilities, there are 3 countries at stake, the Netherlands, Belgium, and Germany. My second subject is the tax-free allowance. The tax-free allowance that can be the amount which is exempted, for instance, for the surviving spouse or for the children. There are 4 cases also which deal with this issue. And these cases are all German cases. Because the interesting thing is that what happened over the past 20 years is that nothing much changed in European law, in the sense that those freedoms were there and they are still there, but the national legislation changed, right? Because it was corrected. And then the third one deals with valuation. There I have a German case, a Dutch case, a Belgian case, and again, a German case. As you will see on the slides, and once again, this is a very ambitious project. I have a lot of slides, and I will go back and forth because they are in chronological order. I put them in chronological order, so I hope the technique won't let me down, but we'll see. But let's start with a quick overview then. These are the cases which have been presented to the European Court, and the European Court ruled on these cases. And if you count them, there are 18 cases. But actually, there are 19 issues at stake, because the XY case, you see it both in the category violation of EU law and also in the category no violation of EU law. That is a bit of a paradox, but actually there are two different questions at stake. And if you look at the violation of EU law and the cases by the the European Court of Justice, you can say that the court actually creates a sort of negative harmonization, because those taxes are in the realm of direct taxes, and direct taxes, they are the competence of the member states. So there is no harmonization, but in a way there's a negative harmonization. I mean by that the court points out that some things are wrong and that you should correct it in your national law, in your national tax law. These cases all deal with requests by national courts for a preliminary ruling. And you know that of the 1st of July 2018, everything is anonymized. So X, Y, B, A. And even the tax office is anonymized. It is V or X now, whereas it used to be Finanzamt Bremerhaven, Finanzamt Krefeld. And Jens Kleinschmidt yesterday told that we will all have fictitious names for the parties involved. But it's interesting to, I haven't figured that out yet. What will happen to the tax offices? Will they all also have fictitious names? That is a bit strange, isn't it? Anyway. The good thing is that gradually everything is brought into line with EU law. That is what we will see. So let's get started then. Just another overview. Gift tax on the one hand, estate and inheritance tax on the other hand. And this is really interesting. Which countries are involved? Germany, Belgium, and the Netherlands. Why, you might ask? Why not other countries? Maybe because Germany, for instance, has a lot of connecting factors. Residence of the heir, residence of the deceased, nationality, the 5-year term. Also to have a place at your disposal. And they may create questions. Because I can imagine that in other countries like Spain, the law also contains flaws. But there are actually no cases by Spanish courts. And then if we look at those cases, who is the winner here? Actually, Belgium is the winner in the sense that 5 out of 5 cases were in violation of EU law. That's really bad, right? And what about Germany? Germany doesn't do that bad. 5 out of 11 violate EU law. And in the Netherlands, it's 50-50, 2 out of 4. And of course, you all know that the Commission can also act on its own initiative if it detects a failure in the law, and sometimes also in response to complaints. And there are also 4 cases dealing with Spanish law, German law, and Greece law. I will not discuss these cases this time. Actually, the first case, which deals with inheritance tax, is Barbier. It's of 11 December 2003. So actually, in December last year, it was the 20th anniversary of these cases, so to speak. And I was planning to write an article on it, but time flies, and now I'm too late already, right? So maybe later on. But what is this about? This is the first case in 4 of 4 cases which deal with that deductibility of liabilities issue. And this is very complicated. Most cases are complicated in the sense that, first of all, you have to know the national law, which may be outdated at the time you're going to study it. And then, of course, there is the question about conformity. Here, I will discuss this case. I will not discuss every case, but to give you an indication. And then later on, if we come to the German case, you will see that there is actually you understand that they are closely linked, all those cases which are about deductibility of liabilities. What is this case about? Here we have a Dutch resident who moves to Belgium. That happened quite a lot to avoid taxation. But we actually follow those Dutch people, because if someone has Dutch nationality, he's considered to be a resident even after emigration for a period of 10 years. But this Dutch national, he actually managed to get out of that 10-year period, and he died at a given moment outside of this 10-year period. But prior to that, he actually sold the economic ownership of his real estate in the Netherlands. He owned real estate in the Netherlands, and he sold the economic ownership of that. And when he died, he had the legal title. And the question is, of course, what is the taxation about? The taxation here is about limited tax liability, cited property in the Netherlands. And you see, in the left-hand corner, there's the Dutch flag. So this is a Dutch case. This case deals with Dutch national law. It's in violation of EU law. It deals with inheritance tax. And what is the case here? Actually, the guy dies, and he has the legal title of this real estate in the Netherlands. And the fact is, what is the value of that real estate, of that legal title of the real estate? Most people will say it is 0, but that's not correct. It's actually, let's say, 100%. On the other hand, there's an obligation, you can read that also in the case, there's an obligation for the guy to transfer the legal title on first call to the person to whom he transferred the economic ownership. So from an economic perspective, there is an asset and a liability. But in our law, that liability was not deductible. And that is strange because, and this is interesting, we always compare the situation where there's unlimited tax liability with the situation with limited tax liability. And in a situation of unlimited tax liability, the guy is simply living in the Netherlands, leaving Dutch property, that would be deductible. And then the court says, it's not okay that it's not deductible in this cross-border situation. So that is important. So this is the first case which actually states that there is deductibility of the liability. And it's not the last case, because if we move on, this is also a famous case van Hilter van der Heijden, which says actually that the 10-year period that we follow our nationals for 10 years is not a violation of EU law. So that will also apply in case of German law, where there's a 5-year period. Belgian case. And in this Belgian case, there's more or less the same question. It's also limited tax liability. And there is, in this case, a debt secured on Belgian real estate. And is that debt deductible? And we use the same mechanism. Would it be deductible in a purely domestic situation in Belgium? And the answer is yes. So it should also be deductible in this cross-border situation when there's only limited tax liability. The next case, and then we move on already to the German case, is quite a difficult one. It's this one. It's a Dutch case again. It's called Arend Sikkens, and it's interesting to tell you that in the Netherlands, we thought this case was so complicated that we abolished cited taxation. Can you imagine? It only yielded 6 million euros per year, the limited tax liability. And this case was really difficult. I will explain it very quickly. Here we have someone who lives in Italy, a Dutch national. He spent over 10 years in Italy, so he's outside the scope of this 10-year rule. And then he dies. And he has a spouse and 4 children and a will. And the will contains a testamentary partition, as it's called, a testamentary partition will. a testamentary parental partition. And what does it mean? It means in this case that the spouse and the 4 children are equal shares. They are heirs with equal shares. But all the assets in the division go to the spouse. And the children have a claim on the spouse. So what happens is, let's presume that, and there's real estate in the Netherlands, that real estate is worth 100, and that goes to the spouse. And there are 4 children, so she has a debt of 80, right? And so she acquires 20, and the children also acquire 20. And according to Dutch law, national law, we say, okay, she acquires the entire house, and the debt, that is not in our national legislation, so it's not deductible. And then once again, the court compared the unlimited and the limited tax situations, liabilities, and said, in a purely domestic situation, she would have paid on 20 instead of 100. So actually that claim, we call it over-endowment debts, they are deductible and they should be deductible. And that makes sense, right? If you compare this case to the previous ones. And now I go to the end. Everything works perfectly. Still. XY. Yeah, XY. XY is actually dealing with a similar situation. What is it about? It's actually more or less a purely Austrian situation. There's an Austrian family, a man, a woman, a daughter, and a son. The man dies. He leaves everything to his daughter. And his wife and the son, they acquired a forced heirship entitlement. But this is not a purely domestic situation because there's real estate in Germany. And who acquires the real estate? The lady, the daughter. But she's under an obligation to pay out money to her mother and her brother. And the question is that deductible? Are those claims deductible? And the answer should be, actually, it's quite predictable. Beforehand, we already knew how this would end, right? If you had looked at the previous cases, this is a no-brainer. Actually, those claims, for as far as they relate to the German real estate, can be deducted from the estate or the inheritance acquired by the daughter. According to German national law, those debts are only deductible if they are economically linked. And the German government said, this debt is not economically linked. But the Court of Justice said, no, but it is legally linked, and that is enough for the deductibility. Sometimes, if there is a prohibition, because this is clearly a prohibition on the restriction on the free movement of capital. How do I know? Because it would actually prevent people from acquiring real estate in another country if this were the consequences, right? And therefore, it is a prohibition. But in some cases, the question is there perhaps an overriding reason in the public interest? And what could that be? Public health, animal health, consumer protection, protection of the urban environment, for instance. But there is actually no existence of such an overriding reason. The German government came up with 2 elements. They said it's the need to ensure the cohesion of the tax system. But it doesn't make sense. I mean, actually, it does the opposite. And it says the principle of territoriality and the need to ensure a balanced allocation of the member states' powers to impose taxes. That doesn't make sense either. And the court says, no, those debts are deductible and there's no justification. So that is one of the issues in the XY case. Now we move back again. And now let's see if that's also possible to our second element. And the second element is the tax-free allowance. And this is only about German national law. We go to a case called Matna. Here it is. And once again, these are cases about Limited tax liability. 4 cases about limited tax liability. Matner is about gift tax. And in Matner, there are 2 Germans, a mother and a daughter, and they both live in the Netherlands for a very long period of time. And the mother wants to make a donation of a land and a house on it in Germany. And she makes that donation in 2007. And the question is there a tax-free allowance? Yes, there is. Actually, it is 1,100 euros, because this is taxation on the basis of CITES, and in the German national law it says, then it's a lower amount, 1,100. Whereas if we look at the unlimited tax liability, it's 205,000. So that's a big difference. And the donee, the lady in the Netherlands, the German lady in the Netherlands, says, I think that I'm entitled to that higher amount. Because why should I have only 1,100 as a tax-free allowance? And the court then again compares the situations and says, yes, it is very strange that the allowance should be low when it's limited taxation. I think personally, it's not that strange that you differentiate between those 2 situations. Because if you say there's worldwide taxation, then there should be a high tax-free allowance. And if there's only limited taxation, it can be a lower amount. But if you start thinking about it, let's presume that it's the only thing that you leave behind, right? And there are no other assets. Then it is really sort of discrimination, and definitely a prohibition or a restriction on the capital movement. So the court says in Luxembourg, no, she is entitled to the 205,000. And a couple of years later, in the Welte case, the question is put to the court again, but now it is inheritance tax. So here we have a Swiss lady. It's a German lady, but she married a Swiss guy and she acquires Swiss nationality. They both live in Switzerland. She dies and leaves everything behind to her Swiss husband. So everything is Swiss, apart from one of the assets of the estate, which is her former house in Düsseldorf. And she leaves that to her husband. And we actually have more or less the same situation. For the unlimited tax liability, the tax-free allowance is 500,000 euros. And for the limited tax liability, it's only 2,000. You can predict the outcome. The court says, yeah, it's not okay. And she actually acquires the 500,000. We had the same in the Netherlands, because that is also interesting to note. If you look at these cases, you think, okay, this is German law, this is Belgian law, this is Dutch law, but there are rules which you can distill from them and which apply everywhere. And sometimes it's difficult. When you're in Spain, you may not be aware of this case, but it applies everywhere. And our Supreme Court actually applied Welte as well for Germans who owned real estate in the Netherlands. But then, as I told you, we abolished our limited tax liability altogether. So you can own real estate in the Netherlands and die, or you shouldn't give it away because then there's immovable property tax. But if you die, there's no tax. So it's a good investment. Next, so this was Welte. And then we go to Hünebeck. You see, it's quite a battle. Hünebeck, what happens in Hünebeck? In Hünebeck, in the meantime, the Germans have changed their law. And they say there is the possibility to opt for full taxation, for unlimited taxation, and then you will get the high amount. The high tax-free allowance. Once again, a gift. Ladies living in the United Kingdom, a mother with 2 daughters. And they make a gift, the mother makes a gift to the daughters of the German real estate. And then the situation is different, because the Dutch tax authorities say, yes, she had the opportunity to actually have the higher amount, but then she should have opted for the broad system. But there is a flaw in that system because it says we aggregate the gifts from 10 years prior to the gift, which is normal according to German law, and also the gifts which follow. So there's an aggregation period of 20 years for gifts, whereas in the domestic situation, unlimited tax liability, it's only 10 years. So another flaw, and the daughters get the full tax-free allowance. Now we move on to XY. So once again, we're at the XY case because the XY case deals with two things, the deductibility of liabilities and the tax-free allowance. Because in the meantime, once again, on the 24th of June 2017, the Germans have changed their law again. And now they have a proportionate allowance. So it's proportionate in the sense that what do you acquire as a whole? What are the CITES assets? This is limited taxation. And then how does it work? And then the good thing is the Supreme Court says that is okay. Yeah, if you have a pro rata allowance, which takes into account that it's only part of your acquisition, those CITES assets, and therefore the big tax-free allowance is reduced, that is allowable. So in XY, we have a violation and a non-violation. And you see, what I try to demonstrate is that the rules, the EU free movement of capital rules have not changed, but the underlying national legislations have adapted itself to that. Okay, now we move back again to the last, and I will go very fast. Do I have some minutes left?
Yes, a couple of minutes.
Great. Because then we move to the BA case. And the BA case is the last case, actually, I wanted to discuss with you. And those cases which deal with valuation, unlike the other ones I discussed, these cases deal with unlimited tax liability. So everything is taxed. And here we have a German, a father who dies and leaves property to his son, who's also a German national living in Germany. So everything is German and there's worldwide taxation. But there's immovable property in Canada. And the rule is that at the time of the case, that real estate, which is let for residential purposes and which is not part of your business assets, is valued at 90%. That is to promote public housing policy. But the house should be in a member state or in a state which is a party to the agreement of the EEA. And here, the immovable property is in Canada. And so it is evaluated, it's valued for at 100% instead of 90, because if it's within the European Union or the EEA, it's a valuation at 90%. And the question is that allowable? And the court says, no, it's not. It's a restriction, because it actually creates a barrier. If you want to invest in that real estate abroad, you know it's difficult because you will be taxed at a higher, for a higher amount. And then the court and then there are two justifications. First of all, Article 64, is there the famous standstill clause? Was this regulation in force on the 31st of December 1993? That's very important, because if it is, it will be respected. For other countries like Bulgaria, Estonia, and Hungary, the date is the 31st of December 1999. So you should take that into account. But here it's the 31st December 1993. And actually, this rule was created afterwards. So the standstill clause does not apply, which means that we may go on to the next phase, which is there an overriding reason? And yes, there could be, because public housing can be an overriding reason. But then the court looks at the regulation itself about the valuation, and it says, does it actually do what it should do, this rule? No, it doesn't, because it applies both to houses in a rural area and houses in big cities. And actually the housing problem, the acute problem, is in the big cities. So it's not focusing on the real issue. And it applies both to very basic houses and luxurious houses. So that's also not apt. And then finally, it does not require heirs to retain their housing for a specified period. So no. So it's not an overriding reason. And then finally, Germany comes up with another justification, the need to guarantee the effectiveness of fiscal supervision. They say, yes, we have to check it. The property is abroad and it's difficult for us. And then the court says, no, no, no. There is a tax agreement between Germany and Canada, and Article 26, paragraph 4 says that there's exchange of information, in spite of the fact that that tax agreement does not deal with inheritance tax. But that doesn't matter, because that particular paragraph applies to all taxes levied in Canada and Germany. So once again, no valid justification. It's actually what I wanted to prove. There's more to tell, of course, but I think it's interesting to stop here. And I think it's clear that there are certain rules which you can distill from the case law of the CJ. And national law changes all the time, but the rules regarding the movement, they are pretty identical over the years and not that difficult. And I hope that I could explain it to you in a way that it makes sense, because it's sometimes difficult if you look at one case, you think, okay, it's very difficult. There's national law. What does the court actually say? But there's logic to it. And that's what I wanted to prove. Thank you for your attention.